Welcome once again to Lehto's Law. Here's Steve Lehto.
A whole bunch of people sent me a very important story about the Fourth Amendment. And the question is, when can you be searched without a warrant? When can your stuff be searched? When could your, cell phone be searched or your laptop? And we've known about this one particular loophole that's existed for a while. So let's suppose you're driving down the street in your town, within your state, well within the borders of the United States of America. Your cell phone, your laptop, those kinds of things would generally require a search warrant for them to get into it, the powers that be, law enforcement. However, the loophole that's been there for the longest time is at the border. So somebody is crossing the border from Canada into America, from Mexico into America, or at an international airport. They just landed and they're coming through customs. They're entering America. And so it's been the case for quite some time that courts have said, well, because you're entering America, and technically speaking, you're not in yet until you've been cleared by customs, anything you got on you is suspect. And so they want to search it, they can. And if you've got a problem with that, well, go back to where you came from. Now, some people have said, well, wait a second. If I'm an American traveling abroad and I come back into America, I have a right to come into America. So if I'm carrying my cell phone, do they have the right to actually say, unlock your phone, let us poke around in there for a while? And up until this case, the courts have overwhelmingly said, well, you aren't in America just yet, and that Fourth Amendment thing doesn't apply because of the extra level of concern we have at the border. So the Electronic Frontier Foundation reports this story. They've been on this issue for quite some time. Sophia Cope wrote this, and a lot of people sent it, so thanks a lot. Federal judge makes history in holding that border searches of cell phones require a warrant. United States versus Smith, a case that came down in May of this year. District Court judge in New York made history by being the first court to rule that a warrant is required for a cell phone search at the border, absent exigent circumstances. Now, other courts have said they'd like to rule this way, but they couldn't because of precedent above them. So what this is setting up right now is that if the United States government wants to challenge this, they can take it up on appeal and see what an appeals court says. And then somebody could appeal that ruling to the Supreme Court and see what happens there. So the Electronic Frontier Foundation has been on this topic for quite some time, is quite happy about the decision, given that they've been advocating for a warrant for border searches of electronic devices, so cell phones, laptops, etc., in the courts and Congress for nearly a decade. If this case is appealed, it'll go to the Second Circuit, and they are urging, as am I, the appellate court to affirm the landmark decision. Now, U.S. Customs and Border Patrol, or CBP, asserts broad authority to conduct warrantless and often suspicionless device searches at the border, which includes ports of entry, at land borders, international airports, and seaports. So if you've ever traveled internationally, or abroad, as we like to say, you know that you go through customs. So they'll dig through your suitcase. Now, they don't have a search warrant to dig through your suitcase, but they dig through your suitcase. So a lot of people would say, well, gee, if they can dig through my suitcase, I guess they could dig through my electronic device. But there's a big difference, okay? Because number one, if you are smuggling something in, most contraband being smuggled in is not digital in nature. And in fact, one could argue that anything that could be smuggled in electronically on your electronic device could have probably been emailed here, okay? So if you're bringing in, like, say, narcotics, they're not going to be inside your phone, most likely. I know someone's going to say, Steve, I heard about a case. But generally speaking, we know that they're actually going to open your phone up and look through, emails, texts, TikToks, and what they're looking for in a phone, I believe, is inherently different than what they might find in your luggage, okay? So for a century, the Supreme Court has recognized a border search exception to the Fourth Amendment's warrant requirement, allowing not only warrantless but also often suspicionless searches of luggage and other items crossing the border. The number of warrantless device searches at the border and the significant invasion of privacy is increasing. In the fiscal year of 2022, CBP conducted an all-time high of 45,000 device searches. Now, the Supreme Court has not yet considered the application of the border search exception to to smartphones, laptops, or other electronic devices that contain the equivalent of millions of pages of information detailing intimate details of our lives, even though we asked them to back in 2021. So the Electronic Frontier Foundation has been working on this feverishly. And so this is a good step in the right direction. But again, we're talking about a district court ruling. And the question then becomes, will it be taken up? Federal appellate courts, however, have considered the question and have dealt with it, such as the Ninth Circuit held that a warrant is required for a device search at the border that seeks data other than digital contraband. Similarly, the Fourth Circuit held that a warrant is required for a forensic device search at the border, but that's in support of a domestic criminal investigation. These courts and the Smith Court were informed by a case called Riley versus California. In that case, the Supreme Court held that the police must get a warrant to search an arrestee's cell phone. But that, of course, was happening within the United States. In the advocacy of the EFF, they have consistently argued that Riley's analytical framework should inform whether the border search exception applies to cell phones and other electronic devices. This is precisely what the Smith Court did in holding that warrants are required for cell phone searches at the border. The court believes it is applying a straightforward logic and analysis of Riley to the border context. In Riley, the Supreme Court applied a balancing test weighing the government's interests in warrantless and suspicionless access to cell phone data following an arrest against an arrestee's privacy interest in the depth and breadth of personal information stored on modern cell phones. So think about this in an arrest situation, okay? You're inside the heartland of America, nowhere near a border, and you encounter the local police. Let's assume they've got a good reason to arrest you. Let's assume that's true. They've got a good reason to arrest you. They then arrest you. You've got on you a cell phone. And they go, unlock your phone for us. And you go, no. They go, well, we'd really like you to. And you say, I don't want to. And they say, well, we demand that you do. And you say, well, I demand you get a warrant. I think the Constitution requires you to get a warrant. Okay? At that moment in time, you're under arrest. Why don't they just go get a warrant? It ain't that hard. And I know some people are probably wondering, gee, Steve, what goes into getting a warrant? Oh, what goes into getting a warrant is that law enforcement has an affidavit they fill out. And they go, I am a law enforcement officer. I recently arrested this person. I arrested them for this reason. When I arrested them, they had on their person this cell phone. Here's why we think the cell phone is important to this investigation, and we ask this court for a warrant to unlock it. And they have to give a good reason. And so they've got time. They've got you in custody. Why not get the warrant? And I've pointed out many situations in previous videos where they could have gotten a warrant if they wanted to, but they didn't. And quite often it's because they know if they go and ask one from a judge, the judge might look at their affidavit and go, that's not probable cause. So the person got arrested, had a cell phone on him. Doesn't everybody these days? Do you have a valid reason to believe that their cell phone contains information about, and you pick some crime that would be very, very distant from a cell phone regarding whether or not the information should be on the phone? So in analyzing the government's interests, the Riley Court considered the traditional reasons for authorizing warrantless searches of an arrestee's person. To protect officers from an arrest, you might use a weapon. Okay, so you have the right to, when you arrest somebody, figure out if they have a weapon hidden on them. You can also take steps to prevent the destruction of evidence. But if you've got the cell phone in your possession, presumably that person who's going to jail cannot destroy the evidence on that phone. The Riley Court found only a weak connection between digital data and these traditional reasons for warrantless searches of people being arrested. Court reasoned that data on the phone can endanger no one, and the probability is small that associates of the arrestee will remotely delete digital data, which, by the way, are both things that people just frantically typed into the comments as things that they thought we missed. The Riley Court also detailed how modern cell phones can, in fact, reveal the sum of an individual's private life, and thus individuals have significant and unprecedented privacy interests in their cell phone data. So you think about intrusions into your privacy, okay? We all have some level of privacy. By the way, it's an extremely long and well-written article by the Electronic Frontier Foundation. It has much more to it, but I'm going to stop right there. But if you think about all of the things that we have in our lives that we consider to be our privacy, places we spend time alone or where we keep the information that's very, very vital to our lives, there's a lot of it perhaps on your computer or on your laptop or on your smartphone. And those things that we consider to be our own and our private, we don't want people snooping through them. And the same reason that you don't want someone snooping through your stuff in your house or snooping through your stuff in your car. Those are all things that seem to be invasions of our privacy. And unfortunately, the way that our modern technology has evolved, we've now got these phones, and I'm only saying unfortunately because of the fact that it's changing that aspect of our privacy. And that is, many people have stuff on their phones that is just as in need of privacy protections as anything they've got in their house, their garage, their car, their office, their wallet, right? And so if you think about all the stuff that's on your phone, could be text messages, could be photographs, it could be all the various programs that track you and show where you were yesterday. And so your phone contains a ton of information. And so earlier in the story, they mentioned that this idea about the government being allowed to search you when you cross the border is an old concept. And it goes back decades, centuries. And we've always been allowed to protect our borders, and part of that was we'd scrutinize people coming into the country. But times have changed. So in the old days, there's somebody stepping off a steamer, and they've got a couple big suitcases, and they go, yeah, I want to come to America and become a citizen and go work in the copper mines of the Upper Peninsula of Michigan. So you poke through their stuff. Oh, you can see what kind of shoes they wear, what kind of blue jeans they might have on them. You might see what kind of other stuff they've packed in their suitcase. And you might actually see everything they own, but it might not be a whole lot. But it's certainly not that intrusive to look at what they're carrying in. Now, they might have something in there that's very private, like a diary or something. But back then, they would not have had anywhere near the stuff that you got on your cell phone. And so what they're carrying in at that point in time, you can understand why digging through it wouldn't be anywhere near as intrusive as digging through today a person's cell phone or their laptop or some other electronic device they've got with them. So this is a good ruling, but right now it is only at a district court level in the state of New York. So it would need to go up on appeal to the Second Circuit and then to the U.S. Supreme Court. This is a case, and this is a topic that is ripe for consideration by the Supreme Court. They're going to have to address this. The question is, are they going to address it now or 20 years from now? And who knows what we'll be carrying in our pockets by then. It'll all be an implant in our head, but that they can download off of using a scanner of some sort. So great story. Sophia Cope wrote it. Federal judge makes history in holding that border searches of cell phones require a warrant. I'm going to tell you right now, a couple days ago, I ran a video at the end of which I mentioned the T-shirts I wear. Many of them have been donated. People send me T-shirts. And there's an address at the end of the video. If you want to send correspondence to me, that's where it goes. And I mentioned that I got a T-shirt in the mail with no note, just third-party shipped it to me. And I opened it up, and it is perhaps the greatest shirt I've ever seen. So while I've been talking, you may have noticed the top of the shirt. And there's no words on the shirt. It is just two world-weary lawyer dogs. And I'm going to stand up in a second and let you see a close-up of the shirt. And I want you to examine the expressions of the lawyer dogs. Because they're smart dogs, but they've seen a lot. And also notice their posture. They got their paws in their pockets, but their ties are loose, like after a good hard day of dog lawyering, as lawyer dogs do. So if you're going to hire a lawyer dog, you'd want a lawyer dog to look like these. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Problems are not stop signs, they are guidelines.